just been involved in a shoot. Was it a good shoot? Was it a bad shoot? Maybe you're not so sure. What's going to happen next? Do you have a self-defense policy with one of these insurance-driven companies? Or do you have the attorneys on retainer in your back pocket? That's right, a real law firm. We're going to break down the differences between exactly what's going to happen and the advantages of the attorneys on retainer program. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the criminal defense attorneys and partners over at the Attorneys for Freedom Law Firm. Today we're going to talk about many interesting topics. How you doing today, brother?
Good, man. This is a video I've been waiting to make for a long time because I think it really highlights one of the very important differences between the Attorneys on Retainer program and I think every other program out there in terms of what people want. And we know what people want, right? You're a responsible gun owner and you are concerned that you might have to pull out your firearm or even discharge your firearm, and you may get charged, and you're worried about having enough money to defend yourself, frankly, and not having to take a deal if you want to go to trial, and these can be very expensive. So that's what the Attorneys on Retainer program is about. But I think people don't really understand that not every shoot's a good shoot.
Yeah, let's talk about just basics here. What do we mean by a good shoot, a bad shoot, a questionable shoot? And what we're really talking about is the legality of that shoot, and very importantly, what the police and a prosecutor and maybe a judge, maybe even a jury consider a good or a bad shoot.
Yeah, right. Certainly, if you're the one who pulled the trigger, you think it's a good shoot. But
maybe not.
Yeah, that's true too. And also, we should point out, it doesn't have to be a shoot. Just because you pulled out a firearm and showed it to somebody, that can be a very serious charge as well. People commonly get charged with aggravated assault charges for pointing a firearm at another person. So it doesn't have to be a shoot. It's really a use of a firearm. And like we said, this could be a good one, a questionable one, or a bad one.
Right, and it's not just pointing a firearm. It's also, we see people charged all of the time for displaying their firearm, simply removing their firearm from a holster, holding up their firearm, telling somebody that they have a firearm can be charged as a crime.
So let's get into it. The issue really on the table, I think, is why does it make sense to have a law firm if these are the things you're worried about, rather than an insurance company or, some club backed by an insurance policy. I think one thing that's really important to recognize is that insurance policies, there's a public policy rule that says insurance companies cannot insure, which means they can't pay benefits for a criminal act or an illegal act. That's why you see these policies that have the insurance companies, they all exclude criminal acts. They say, look, if it's a criminal act, no coverage for you. And in fact, if you read the policies, many of them are written in ways that they make it sound like it's a civil matter. They talk about the claim, not the criminal charge, because it's written in the language of a civil matter.
Yeah, it would definitely be illegal if any of these companies openly said, yes, we insure criminal acts. That would be definitely an illegal contract.
Yeah, and of course, no problem for a law firm. I mean, that's criminal defense lawyers do. There's no question about if it's a criminal act, you still get a criminal defense attorney. So essentially, there's three different varieties of charges or shoots or displays of firearms. I think it would be fair to break them down. Group number one, the clearly good shoot or display of a firearm. Group number two, the questionable shoot or display. And third, the bad shoot. And we want to break each one of these down.
Let's start with number one. Okay, so what happens if you're in a good shoot? In other words, you act validly in self-defense under the laws of your applicable jurisdiction. You defend yourself either by discharging the firearm or displaying it successfully. It was absolutely legally unimpeachable self-defense. Everybody agrees it's a good shoot. What happens?
Yeah, by the way, another way to say this is you acted reasonably, because you see the word reasonable in virtually every self-defense statute. So this kind of a situation where it's clearly a good shoot, you're probably not going to get charged with a crime. And normally, if it does happen, we can get rid of the case pretty quickly.
Yeah, here's how it looks from our perspective. A client will call our law firm and say, I was just involved in a shooting. I need to speak to an attorney. I'm worried I may be charged or I may be arrested. They'll come in. We'll sit down with them. We'll go through the facts with them. And Mark and I have a pretty good feeling after doing many of these cases what a good shoot looks like, right? It has things like imminency, the need to do it immediately, proportionate force, somebody's actually threatening your life, serious physical injury or death. We know the hallmarks of a good shoot, and most of the time, if those are the facts that we're hearing and we have reason to believe that they're accurate and we don't see anything that contradicts those facts, Mark and I will turn to people and say, you're probably not going to be charged here. And, we'll take precautions. We'll call up the prosecutor, maybe even the detective involved, and we'll talk to the prosecutor making the charging decision. And if they agree with those facts, that it was actual good legal self-defense, they're not going to err on the side of charging them. This first variety that we're talking about, the obviously good shoot that the prosecutor takes a pass on, is definitely the minority of the three types of shoots that occur. We definitely see more in categories 2 and 3 than we do in obviously completely unimpeachable shoots. They're pretty rare.
Yeah, I think that's fair, especially in today's world, right, where the prosecutors are so careful to look at any use of a firearm, right? There's so much political pressure going on right now. If you pull your firearm, they're going to look at this thing, and I think they're looking at it and say, is there some way we can bring this case? Right. Yeah, for sure. I think that's a good point.
All right, let's talk about type of shoot number 2, the questionable shoot. So this is where maybe there's some question as to whether you acted reasonably, whether you engaged in valid self-defense, whether you didn't fall afoul of some problem in the law, defense of property, or using disproportionate force or something like that. There's all kinds of different little snags you can hit that may or may not be applicable in your self-defense shooting. And this is when it makes the case fall into category number 2, which this is a questionable shoot. What happens after a questionable shoot, Mark?
Yeah, and oftentimes what makes it questionable is a discrepancy on the facts, right? Defendant comes in and says...
Almost always.
Yeah, a client comes in and says, hey, here's what happened, and the prosecutor says, no, that's not exactly the version that I have, and so usually we're fighting about the facts.
There might even be a question as to who's the good guy and who's the bad guy.
That's right, yeah.
Or whether they're both bad guys.
That's right, yeah, that's true. And so in this variety of incident, if you're dealing with one of these companies that's backed by an insurance company, let's call the good ones and the bad ones, right? The bad ones would be ones who would say, if you do get charged here, sorry, we don't cover criminal acts, we don't cover illegal acts, right in the contract. And if they wanted to, and I'm not saying they're all going to do this, but if they wanted to, they could say, you bought this policy, but look right here in the exclusions, it says we don't cover criminal acts. You're charged with a crime. We're not going to cover it. Now, as we've pointed out in some of our videos, this has happened before with some of the other companies.
Even before a conviction, some of these other companies have completely dropped people from coverage, even while they were protected by the presumption of innocence.
That's right. So don't be fooled that there are times when some of these companies that deal with insurance companies are going to say, look, we've decided that this thing is a bad shoot. And of course, they can always rely on the fact that somebody has been charged. They also know very high percentage, 95+% of cases, somebody's going to take a plea. And so probably they're going to be justified in just saying, sorry, no coverage for you because we exclude criminal acts. And so you're out. If you get one of those companies, you're out. Now, as to the other companies, because there are good people who we're competing with in some of these other programs that are trying to do the right thing, and they'll say, look, even though the person is charged, it's a questionable shoot, this person is still presumed innocent, and because of that presumption of innocence, we will give you an attorney to defend yourself.
Yeah. Okay, and so no problem with attorneys on retainer, obviously, when it comes to a questionable shoot. We will not drop you. In fact, we're excited now because there's some interesting issues in the case. There's some facts to talk about. Also, we don't subject our clients to any of the numerous exclusions that you can find in all of these contracts.
This is a great point because even of the companies who are the good companies and say, look, it's questionable, but there's a presumption of innocence here, we are going to definitely afford coverage, they're going to go down what is usually a very long list of exclusions. And if any of those apply, if you don't run that gauntlet of exclusions and clear them all, they're going to say, no coverage for you. So we've already talked about the criminal acts exclusion. There's several others, right? There's the negligent discharge, which is very common in some of these policies. The presence of alcohol or drugs, which is really common, right? Lots of times things happen happen where people are out, they're partying, it's in a social setting.
Or perhaps they're at their own home having a glass of wine at the end of the night or something like that. Somebody breaks in or something happens there. All these other companies that exclude for the presence of drugs or alcohol have the right to say, sorry, you don't get to be covered. You don't get to defend yourself and be covered by us in that type of situation.
And I think it's fair to say that's most of them. Look, if you're in one of these policies, take a look at it and take a look at the exclusions, many other exclusions as well. The weapon that you used, is it illegal for any particular reason?
Could be like a serial number's wrong, or maybe it's too short or something like that. They say, sorry, we're not going to afford you your right to protect yourself and be covered by this policy.
Yeah, you may have modified it in some way. You might think it's right now we have the FRT trigger issue, something like that. If it's illegal in any way, you're out. Some companies say, look, if you didn't use a firearm, we only cover it if there's firearms. Other types of weapons are not covered. Again, none of this is any problem with attorneys on retainer. Also, places. It's getting more and more common for places to exclude firearms from the premises, right? That's what so much litigation is going on now as a result of the Bruin case, where they sort of left open the door. They said sensitive places, whatever that means, you can ban guns from. And so some of these anti-gun type states have attempted to call a sensitive place so many different spots, essentially make their entire city or state a sensitive place. If you're in one of those areas, then sorry, you're in an illegal spot. It's illegal for you to have a firearm. That's an exclusion. No coverage for you if you're in one of those policies. Again, this is another one. Even if this happens at a place where firearms are prohibited, no problem with attorneys on retainer.
Yeah, that's a ridiculous exclusion to me. I mean, it's the insurance companies basically saying your right to defend yourself ends when you enter a certain location, which is really a different analysis, right? We have a different crime for that under the criminal code that has nothing to do with self-defense. So it's a ridiculous exclusion.
Look, if you're looking for ways to exclude people from coverage, that would be a really fine one to pick.
So is this next one, Mark.
Next one, too?
This one's ridiculous. So a lot of these companies say if the act that you're accused of has to do with domestic violence. So let's talk about that.
This is huge.
This is massive.
I mean, if you on all the cases that involve a familiar person, right, an ex-husband, an ex-wife, ex-boyfriend, girlfriend, family member.
Well, I'm glad you phrased it like that, like familiar person, because there are many states, like many of the states that we practice in, have a much more expansive definition of what fits a domestic violence relationship. It can even include things like roommates or former lovers, or maybe that second uncle who you might share a little bit of blood with, blah, blah, blah. These companies that say, sorry, if it's domestic violence, we're not paying for your defense, is a massive, massive net.
Yeah, this is a huge swath of cases that they're saying, if you're involved in one of these, even if it's a legitimate act of self-defense, sorry, you're excluded from coverage here. Again, no problem with attorneys on retainer. This is, again, I mean, this stuff to me reeks of companies that are trying to find ways to not afford coverage to people.
Absolutely. Next is absence of a CCW permit in a state that would otherwise require one. This kind of goes, in my opinion, into the same type of exclusion as that prohibited places exclusion, where it's like, okay, well, that's a different analysis. It's a regulatory violation that they're talking about, and that has nothing to do with your right to defend yourself from an aggressor. So this seems another ridiculous exclusion.
Right. We don't care about that stuff. You didn't have a CCW. Okay, you probably violated a different section of the law, but we're interested in the self-defense. Shoot, that's what we defend. And so that is another potentially huge exception. And then the final one, prohibited possessor status. All right, you may know if you're a prohibited possessor. That means you can't have a firearm, but you may not know.
We have people in our office all the time that come to us and try to get their gun rights restored who tell us, I had no idea. Apparently I had something from 1996 that was like a DV in the state that I was in, but I didn't know if it was a DV, and apparently I'm a prohibited possessor. These things happen.
Yeah, they come up a lot of times in misdemeanor domestic violence cases, right? Somebody threw the tuna casserole at somebody else. They got into a disorderly conduct. They took a quick deal. They paid $200, went to counseling or something. Now they became a prohibited possessor under federal law. They didn't even realize that was the case. Another way this comes up is the restraining order. Somebody gets a temporary restraining order. You know, you had a bad breakup or something. The judge checks the box that says no guns for you. Now you're a prohibited possessor. A lot of people don't read this stuff. Okay, so if you're a prohibited possessor and you get into a self-defense shoot, you're excluded with many of these companies. Again, none of these are exclusions for attorneys on retainer.
No problem at all for us. All right. What else is there to say about the questionable shoot, Mark?
Well, you have other things as well. So many of these companies, you really have no idea who your lawyer is. This is another problem. And different companies have different policies here, but so many of them, and I've reviewed several of them, sure, you get to choose your lawyer, but only if they approve. Other places, you only get a lawyer that's approved on the list. So you may not know, and probably don't know with many of these other companies, who your lawyer is if you're involved in one of these shoots. And then I think this is another huge thing. Even in the case where the insurance-based company says, look, you're charged, but we're going to say it's a presumption of innocence. We're going to afford you coverage. What happens when you plead guilty? Right. And you may or may not plead guilty.
Which has an extremely high chance of happening, just statistically.
Yeah, statistically wise, you're probably going to take a deal. It's 90-something%. Now, this doesn't mean always it's going to be a bad result, right? I mean, you can imagine cases where, and we've had some of them where people are charged with crimes that they're looking at 20 years plus. We've literally had cases where people have taken deals to probation, several of them in those situations. Client is thrilled. But now you've gone in and pled guilty. And in virtually all of these cases, the policy will say, well, if you plead guilty, now you're out. We definitely can't afford you coverage any longer, which always leaves the question in my mind, who's going to represent you at sentencing?
Just to be clear, procedurally how this works for people who don't know about the criminal justice system is when you take a plea of guilty in the felony world, it typically doesn't go right to sentencing. Usually there's a time period that leads up to a sentencing hearing where your attorney's doing a lot of important stuff, preparing the court, preparing your character references, preparing mitigation for the judge to present in order to try to convince the court to give you the most lenient sentencing possible, but you've still technically pled guilty to a criminal act at that point. What happens with these insurance companies who are not allowed to cover you after that moment in time?
Yeah, you make a really good point because in almost all pleas, there's tons of discretion for the judge, right? So somebody who takes a plea is looking and their lawyer has said, okay, you could get this, you could get that, you could get anything in between. You're really hoping you get what's on the low end. And so a lot of work needs to be done between that change of plea hearing and that sentencing hearing or pre-sentence hearing that's coming up. And many of these companies will say coverage immediately ends if you plead guilty or if you go to trial and you're found guilty.
Coverage stops in the event of a conviction. Any insurance company that tells you that they do something different is either not being truthful or they are breaking the law.
Now you're in the same situation. You're looking at a sentencing. Do you lose your attorney there? I don't know how that works. Some of these companies also have repayment provisions where they say, hey, we expended a bunch of money and now you've pled guilty. It's actually a criminal act. We want that money repaid. Why do they do that? Because they want to say to the insurance commissioner, look, we're really not covering criminal acts.
Right.
In fact, we didn't have any idea this thing was a criminal act. The guy pled guilty. Now he's got to pay us all the money back. Do you really want to be in that position? That's the position you might find yourself in if you go with one of these companies that's backed by an insurance company that specifically says we do not cover criminal acts.
And I think it's really important here to mention that if you're in this second category of shoots, which is the questionable shoot, maybe there's some good facts, some bad facts, some disagreements between your counsel and the state's counsel about the facts, that makes it much more likely that you're going to take a plea, right? Because there's going to be a lot of back and forth and negotiation where both sides are going to say, well, if the jury believes my set of facts, then this is going to happen. Well, if they believe my set of facts and so on. So it's much more likely when there is a contested case for you to take a plea. I think it's worth mentioning.
That's a really good point, Andy, because the other thing that I would mention here is almost all of these gun-related cases are going to have mandatory minimum sentences. And so what they know is if you want to roll the dice on this kind of a case at trial, you're probably looking at a lot of time if you lose. And if it's really a questionable shoot, you might not want to take that chance, and you probably don't if your lawyer can get a deal on the table that you say, look, it's not exactly what I wanted, but I don't want to take the risk at trial. I'm going to take this deal. Okay, what position are you now going to be in with the insurance company that's controlling the purse strings and paying your lawyer? Look, I can't speak to that, and they're all different, but this is something worthy of your attention if you're with one of these other programs.
Let's move on to shoot variety number 3, which is the bad shoot. Now, this happens a heck of a lot more often than people may believe. We've had so many people. I can't even fathom how many people we have had in this office over the years who come in and say, I never thought it would happen to me, but I was in an extraordinary situation and I realize I screwed up now, and I'm really scared what's going to happen to me. Happens all the time.
I can hear the people listening to this video or watching this video right now saying, well, look, I've got training, I'm experienced, I'm just never going to be involved in a bad shoot. I hope you're not, but you might be. Why? Because you don't get to pick the time and place of the incident, right? Sometimes you're totally prepared and alert and ready to go, and you know how to respond and think clearly in just a few seconds. And other times you're not. That's just life on Earth, right? There might be times when an incident can occur in the middle of the night. Maybe you're in a deep sleep and you're awakened. And, it's that horrible hypothetical that we get asked all the time. I'm home and I'm sleeping. It's the middle of the night and I hear a thug and some guy's in my room or something. You got to make decisions on the spur of the moment.
Maybe you were drinking that night before you went to sleep. And so when that moment happens that you're not planning or prepared for, you get up and you're not in the best condition to make a reasonable decision as to self-defense at that point.
Yeah, you could also be very angry. Something might have just happened and you've sort of shut off the rational part of your brain, the part of your brain that thinks clearly and what's reasonable. Instead, you're in a rage. You've sort of lost your reasonable brain has gone out the window, and now you're upset, and maybe you're not making the best decisions. You flipped out.
You could simply be mistaken about the facts. You could simply be mistaken about somebody's role and what they're actually doing, what they're not doing, whether this is a break-in or whether this is somebody outside of your house picking up an object that they dropped on your lawn or something. We don't know.
Look, police officers get a lot of training on this stuff, and they still get involved in bad shoots. It happens. People make bad decisions in the heat of the moment. These are hard situations, and no matter how much you think you've got training and you're reasonable and responsible, you might make a bad decision in the heat of the moment and be involved in a shoot that we all look at and say, you know what, this is a bad shoot.
Really, most of the times that a bad shoot occurs with what I would consider to be an otherwise very competent, very wise gun owner, because we certainly represented many, it would blow people's minds to know how many excellent, competent, responsible gun owners we've had to represent on bad shoots. Typically, what this boils down to is proportionality and imminency, right? They used a little too much force or maybe just went a little bit beyond proportionality in their decision-making. And just the slightest misjudgment here could mean years of time if you're convicted.
Look, we have a whole category we call imperfect self-defense. It's an unreasonable but honest belief. You made a mistake, it usually will get you a lower conviction on a lower crime than the charged crime. But there are many different ways here, right? Maybe it wasn't as imminent as you thought. You flipped out a little bit. That person might have turned to leave and you fired a little bit late and they make the argument it wasn't imminent. Maybe you used deadly physical force to protect property, which is not allowed in, I think, virtually everywhere. I know there might be some exception in Texas. I'm not sure about that. So it's really easy to be involved in a bad shoot. The question is, what happens if you're with one of these other companies and you're actually involved in a bad shoot?
Well, if it's determined that you were in a bad shoot by that insurance company by one way or another, one thing's for sure, they cannot cover the legal fees of a criminal act, and your coverage is done.
Yeah. In fact, if you're in one of these policies, if you've got one of these policies backed by an insurance company, you should probably call them up and say, look, I know that, I'm probably going to be involved in a good shoot, but what if I'd make a mistake? What if I'm actually in a bad shoot and you guys look at it and say, yeah, we conclude it's a bad shoot. Can you still represent me?
This is an interesting challenge to put to all of those insurance companies. Yes, if you are on one of these policies or maybe you're shopping around comparing them, it's kind of an interesting challenge for the viewers, Mark. Call their customer service and ask them, are you guys able, if I make a misjudgment, to still cover me in the odds of a bad shoot? If they say yes, they're breaking the law. That's an illegal contract.
Yeah, I think if you tell them in advance, look, we're going to record the answer and I'm going to post it on the internet. Just let me know if it's actually a bad shoot. Will the insurance company still come up with the money to pay? If we all agree it's a bad shoot, I think the honest answer for them is no, because they're an insurance company. So what are you left with? You are left hanging.
When you most need help, after you've been involved in something like this. Now you got the full force of the government coming at you. You got a massive charge, usually involving years and years and years of prison. This is when you need help the most. This is exactly why you get one of these companies, is to be protected when you're in a vulnerable position like this.
This right here is where the rubber hits the road on the difference between an insurance-backed program and a law firm, right? Because with a law firm, there is no problem with our law firm representing you if you actually committed a crime. That's what we do. We represent people who actually did commit the crime. And we still, look, the job is still, they got to still prove the case, right? We believe, like the founding fathers believed, that better that 10 guilty go free than one innocent get convicted. We're real defense attorneys at our firm. And even if you're actually guilty of the crime, the government has got to dot the I's and cross the T's and prove every element of the charge beyond a reasonable doubt before they get to put someone in the cage. And if somebody actually guilty goes free on our watch, I don't feel bad about that. We are defending a very important principle in our Constitution. It's a due process matter. It's a criminal law matter. Sorry, if the government doesn't prove the case beyond a reasonable doubt as to every element, they don't get to put someone in a cage. We can say that as a criminal defense law firm.
You can't say that as an insurance company. It would definitely be breaking the law to have such a policy. No problem for real criminal defense attorneys, and that's what really sets our law firm apart from these other services.
Yeah, I think that's the real reason for legal defense. You want a law firm, not an insurance company.
All right. Well, that was a fun discussion, Mark. I hope everybody will do their own research onto all these companies and the difference. We are the only law firm that we're aware of offering a service like this. And it's really about time, frankly, because there are some huge differences between what a real law firm can do for you and what one of these insurance-backed programs can do for you as well. If you want to learn more about the Attorneys on Retainer through the Attorneys for Freedom Law Firm, go check out attorneysforfreedom.com. You can also check out attorneysonretainer.us. Also, leave us a like, subscribe to this video, leave us a comment. It's because of you guys that we were able to make this program so great. It was literally just years of asking you guys in our videos, what would you like to see in these programs? And we've added all the features based on the feedback you guys have given. We really are interested in making the best product on the market. Definitely leave us a comment down below. We'll get back to you. Until next time, my friends, this is attorney Andy Marcantel and attorney Marc J. Victor. Peace.
Peace.